As a complaint. Right.
Yes, just a moment, Counsel. This action was commenced at the instance of the claimant. Counsel, are you with me, please?
Yes, my lord. We are with you, my lord.
This action was commenced at the instance of the claimant via the complaint dated and filed on 7th November 2024, alongside the statements of facts, witness statements on oath, among other accompanying processes. In the said statement of facts, the following reliefs are sought by the claimant. A declaration that the suspension of the claimant from activities of the first defendant is unconstitutional, illegal, null and void, and of no effect whatsoever, having been convened or held without compliance with extant provisions of the first defendant's constitution, regulating meetings, taking decisions, and passing of resolutions. 2. Orders setting aside the purported suspension of claimant from activities of the first defendant is unconstitutional, illegal, null and void, and of no effect whatsoever, having been convened and held without compliance with extant provisions of the first defendant's constitution, regulating meetings, taking decisions, and passing of resolutions. 3. Order directing the second and third defendants to pay the claimant jointly the sum of 20 million naira only, being general damages suffered as a result of the illegal suspension and publication of the defamatory words, derogating the image of claimant as contained in the correspondence between the claimant and second defendant, and which defamatory words were contained in the letter written by the second defendant. 4. And any other orders as court may deem fit to make in circumstances. After receiving service of claimant's processes, defendants jointly filed their memo of appearance on 25th November 2024 and subsequently statements of defense with relevant accompanying witness statements on oath dated and filed 2nd December 2024, after which pleadings were closed. In the course of trial, claimant testified at CW on 21st March 2025, during which he tendered exhibits C1 to 3, which were admitted by the court in evidence. From 5th June 2025 to 24th July 2025, defendants through Isia Bakori, that is second defendant, gave evidence and tendered a single document admitted as exhibit D1. At the end of hearing and upon the order of court, defendants filed their final written addresses on 12th August 2025, after which claimant filed his own final address 2nd September 2025. Lastly was defendant's reply address filed on 15th September 2025. All addresses were adopted 2nd December 2025. A brief summary of the claimant's case is that he was employed by the first defendant and that on 31st October 2024, second defendant and secretary of first defendant single-handedly wrote a letter suspending him as captain from the activities of first defendant without compliance with relevant provisions of its constitution and rules, nor was he accorded fair hearing. He added that the reason for his purported suspension was hinged on a letter of restructuring written by the claimant on behalf of the executive members of first defendant to the secretary of Nigerian Polo Federation. Also that the said letter of restructuring was viewed by the defendants as capable of brewing disharmony among its members. Finally, claimant alluded that allegations and decisions suspending him were serious and made to defame his character, thus necessitating this suit. On its part, defendant's case is that claimant was suspended by a letter written by second defendant on the instruction of fourth defendant and on behalf of the first defendant for reasons already contained in this case. Defendants also stated in their defense that they did not breach any right of the claimant, as the suspension was to give room for investigation into the case and thereby reach a just decision thereon. However, that claimant rushed to court with this suit, whereas his action is still inchoate. In all, the court was urged to dismiss claimant's case for lacking in merit and being gold digging. The claimant's counsel in final written address distilled the two issues for determination. I will read only the issues. The arguments are contained in the body of judgment. One, whether the second defendant has the power under the Constitution of the first defendant, as well as the Constitution of the Federal Republic of Nigeria 1999, to suspend the claimant in the manner he did without affording him fair hearing. Two, whether the contents of the second defendant letter accusing the claimant of attempting to cause disharmony without proper investigation amounts to defamation, entitling the claimant to damages. I earlier on mentioned that the issues have been argued and contained in the now the submissions of the defendant's counsel as contained in final written address. Equally, two issues have been formulated. One, whether the suspension of claimant was unilateral, illegal, and unconstitutional to warrant the grant of claimant's release. Two, whether this court has jurisdiction to entertain a claim of defamation and whether the claimant has proved the allegation of defamation. Equally, the issues have been argued. The defendant went on to file a reply address to the claimant's final written address. Equally, the arguments are contained in the body of the judgment. I shall now proceed with the decision of the court. I hope counsel are with me.
Yes, my lord.
All right, thank you. I shall proceed with the decision of the court. This case
As
was
the
filed at the
parties.
instance of the claimant, challenging his suspension by the defendant by Exhibit C1, which is suspension letter dated 31st October 2024, and alleging that it was defamed by the content thereof, thus claiming for damages in that regard. Having carefully gone through the pleadings of parties, the totality of evidence adduced, and written submissions of counsel to both sides, I have distilled the following issues for the just determination of this suit: whether the suspension of the claimant was done in accordance with relevant rules and consideration of the principles of natural justice, whether this court has jurisdiction over matters bordering on the tort of defamation, whether claimant has established the allegation of defamation against defendants to entitle him to damages. The initiating grounds of claimant's case is hinged on the suspension by the defendant as contained in Exhibit C1, which his counsel argued that same was unlawfully meted against him. Suspension in itself is a disciplinary procedure which temporarily deprives an affected employee from entitled privileges and rights that naturally flow with the employment. It is a disciplinary procedure that temporarily bars an affected employee from his regular occupation for a fixed period or indefinitely. This is usually with the object of giving the employer the chance to make up his mind as to what should be done to the employee facing the discipline. Suspension in itself is not termination or dismissal of the contract of employment. It merely operates to suspend the contract rather than terminate the contractual obligation of the parties to each other. See cases of Yep versus Samuel, and equally Nweke versus Unizik Oka, amongst other cases cited. Citations are equally all provided. The first leg of the challenge to claimant suspension is that it was unilaterally done by second defendant, who is the secretary of the first defendant association. Also, that it is the management committee of the first defendant that has power to suspend him in a way of exercising disciplinary measures, after the steering committee of the defendant may have made a recommendation in that regard, and to refer the court to paragraph D4 of Exhibit C2. The defendants, on the other hand, have denied such claim. I have considered the submissions of parties regarding the instant issue and taking cognizance of the contents of Exhibit C1 and C2 in particular. It is apparent upon a careful scrutiny that the suspension letter was written and signed by second defendant as secretary of first defendant upon the instruction of fourth defendant, who is the chairman of the first defendant. That being the case, I find it impossible to see how one can view such as being a unilateral decision of the second defendant when the whole gamut of the letter shows on face value that he was acting in an official capacity and with the full knowledge of its chairman.
as a
It
puppet.
is settled law that documentary evidence is the best form of evidence, and upon it, all oral evidence are being weighed and tested. Also, that oral evidence cannot, by any stretch of imagination, be used to impeach the authenticity of documentary evidence. I thus find that the claimant's assertion that his suspension was a unilateral decision of the second defendant is baseless and without merit, and I so hold. Onto
Is
the
it?
second leg of claimant's grounds over the suspension, his counsel argued that because the suspension was made without issuing him any query or notice of allegation, it is wrongful and that he had been prejudged as an offender already, hence breaching his constitutional right to fair hearing. Defendants have held on the fact that, as captured in Exhibit C1, the suspension was meant to pave way for investigation into the allegations against claimants and not to serve as a punitive measure. Exhibit C2 does not spell out the disciplinary procedure that will be taken whenever the need arises. However, it is a general position in the labor law parlance that a disciplinary process involves a letter of allegation, an opportunity for the employee to respond, and potentially a hearing. I find it of utmost importance to point out that I have observed from my records that defendants failed to issue a letter of query to the claimant, but proceeded to issue a letter of suspension, thereby suspending the claimant without giving him the opportunity to make representations in his defense. Again, I have viewed with due diligence the content of Exhibit C1. The heading reads Letter of Suspension from Activities of Sokoto Polo Club. Paragraph 8 states thus: this suspension is indefinite with effect from the day this letter is delivered to you. It is tried that in the interpretation of any status of contract or document, where the words used therein are plain and unambiguous, then the ordinary or literal rule of interpretation should be applied, as it is only where the ordinary or literal meaning of the clear and plain words fail to bring out the intention of the lawmaker or leads to absurdity that resort is hard to constructive interpretation. See Dixon versus Silver. My take from the above is that there is no gainsaying that claimant suspension was meant to be indefinite or an unspecified period of time. Suspension in itself is a well-recognized tool of discipline. There is, however, a clear distinction between an administrative suspension pending investigation for an alleged wrong and punitive suspension. While the former is often used to protect the business of an employer or its employees and the organization at large, pending the outcome of an investigation against an affected employee, the latter is a punitive measure meted on an employee when a misconduct has been established, generally after conducting investigation and affording fair hearing. The defendants placed the claimant on indefinite suspension, which I must emphasize is punitive in nature, without any query, and before affording the claimant opportunity to make representations in his defense or establishing the guilt of the claimant. It is against the tenets of fair hearing and natural justice for an employee to be suspended when he has not been queried and accorded fair hearing. CUBA PLC versus Oranuba. It is unjustifiable to place an employee on indefinite suspension, as it amounts also to unfair labor practice, which this court, by virtue of Section 254C1F2H and 2 of the Constitution and Section 13 and 15 of National Industrial Court Act 2006, is enjoined to execute. In SPDC Limited versus Semehu Supra at 377 paragraphs D to G, per Monica Dongbe Mensem JC, as it then was, in his contributory judgment, held that when an employee is placed on suspension, he is placed on hold. He lives day by day in anticipation of either being recalled or being laid off. He is not at liberty to utilize his time elsewhere, nor as he desires until after closing hours. To have kept an employee on suspension for that long is in fact what is unjustified, cruel, and unduly oppressive. On this score, I find that the suspension of the claimant indefinitely to be an unfair labor practice, and I so hold.
Scott, please.
So I would rather have it that I find that the indefinite suspension of the claimant is an unfair labor practice, and I so hold. Issue 2.
As a
This issue borders on the jurisdiction this court to hear and determine matters on the tort of defamation. While defendants hold the view that this court lacks jurisdiction, claimants counsel argue to the contrary, pointing out that the said defamatory acts complained of arose from the employment of relationship between parties and those covered by Section 254C1D, 1999 Constitution. Now there has been, as it were, oscillating decisions of Court of Appeal over this court having jurisdiction to hear and determine matters bordering on the tort of defamation, that is both for and against, on them which was the most recent in line. EcoBank, Nigeria Limited and others versus Idris, where it was held that National Industrial Court lacks the jurisdiction to hear and determine suits that borders on the subject matter of defamation, even though it arose from a work or employment relationship. However, in 2025, the Supreme Court in the case of Emma Elegbe and another versus HP International School Limited and others held that National Industrial Court has jurisdiction to hear and determine issues bordering on the tort of defamation, so long as the facts therein show that the defamation complained of was intrinsically connected with the employment and the determination of the rights, duties, and obligations of parties cannot be adjudged without the recourse to them. That such is covered by Section 254C1D, 1999 Constitution. Going by the principle of stare decisis and the fact that the above decision is later in time to any previous ones affirming the court's jurisdiction over claims for damages arising from defamation, I am bound to follow the latter decision and would in this wise consequently hold that this court has the jurisdiction to determine the claim for defamation in this suit, especially as the defamation claim is intrinsically tied to the suspension of claimant. Issue 2 is thus resolved against the defendant and in favor of the claimant, and I so hold. Now, on the third issue, having raised allegations of defamation, the claimant is saddled with the responsibility of proving same by credible evidence. See sections 131 to 136 of the Evidence Act 2011. The Supreme Court in the case of Chilkett Security Services and Dove Farms Limited versus Schlumberger Nigeria Limited and another defined defamation to consist of the publication to a third person or persons of any words or matter which tend to lower the person defamed in the estimation of right-thinking members of society generally, or to cut him off from society, or to expose him to hatred, contempt, opprobrium, or ridicule, or to injure his reputation in his office, trade, or profession, or to injure his financial credit. It is not in contention that defendants authored Exhibit C1, which contained the alleged defamatory words. Neither is it in doubt that such were made, referring to the claimant, and actually published to other third parties, as the Nigerian Polo Federation, the members of the Sokoto Polo Club, etc. See Exhibit C3. However, the defendants on their part have claimed that there was nothing defamatory in the said Exhibit C1, as they only reflected what transpired. The Supreme Court in the case of Abalaka versus Akinshete and others, 2023, LPLR 60349, delivered 3rd March 2023, while relying on its earlier judgment in Oto versus Ecom 2006, 9 NWLR Part 986 at 533, where it held that, I quote, if a statement complained of appears to be derogatory or disparaging or injurious to a person so as to impeach his character or reputation, it may still not amount to defamation unless the party or person complaining proves that it was a false statement, unquote. Also held was that in an action for any form of defamation, it is essential for the plaintiff to establish falseness of the material statement, failing which the defender will not even be called upon to enter a defense. Having laid the basis above, it becomes necessary to find out if the claimant was able to show that the statement made by the defender was indeed false. From observation of the evidence before this court, claimant specified that the defamatory words were contained at paragraph 6 to 8 of Exhibit C1. I have dutifully considered same, and paragraph 6 to 7 states thus, I quote, the chaos your actions will cause will have negative effects on the gradual approach come well-meaning members are making to attract external interventions in the required infrastructure development. Consequently, in view of the offences we committed, Sokoto Polo Club chairman Alhaji Bala Shagari has verbally, through phone, directed that you be suspended from all activities of Sokoto Polo Club, pending the outcome of investigations to be conducted by both the management of Sokoto Polo Club and the executive committee of Nigerian Polo Federation to determine the next appropriate further line of actions, unquote. I have observed as submitted by the defendant counsel that paragraphs 1 to 5 gives a narrative of the circumstances of claimant's actions via Exhibit D1, a letter signed by him which sought to replace the management of Sokoto Polo Club and addresses to the Secretary of Polo Federation, to the Secretary of Polo Federation, which was perceived as an abuse of protocol for not having the consent of the management committee of first defendant in addition to the management members not being aware of its content. It was sequel to the perception of claimant's alleged infraction or breach of protocol that gave rise to paragraph 6 above and its consequent suspension paragraph 7. It is the view of the court that paragraph 6 to 8 in the face of Exhibit D1 signed by the claimant containing the allegations of breach of protocol against him. I find that a holistic reading of same shows that there was nothing defamatory regarding Exhibit C1, seeing that there was to be further investigations into the issues at stake, and I so hold. The only snag I see in the said Exhibit C1 was that claimant, as I already held, was suspended particularly indefinitely without first hearing him or even issuing any query. Yet, that is not sufficient to ground the assertion of defamation against the defendants, and I so hold. Thus, issue 3 is resolved in favor of defendants and against the claimant. From the rationale construed in this judgment, it is without contention that indefinite suspension without pay is unjustifiable and a distressing experience for the claimant. However, there was nothing in the claim suggesting claimant was denied payment of his salaries and neither any claim in that regard. But the said suspension, having been found to be wrongful and contrary to the principles of natural justice, same is liable to be set aside and is so set aside. On the whole, the case of the claimant succeeds only in part in the following terms. 1. It is hereby declared that the suspension of the claimant from the activities of the first defendant is unconstitutional, having failed to comply with the principles of natural justice. 2. An order is made setting aside the indefinite suspension of the claimant from activities of the first defendant for being unconstitutional and for failing to comply with the principles of natural justice. 3. Review 3 fails and is refused. Judgment is entered accordingly.
As court please.
We thank my Lord for the well-considered judgment. Thank you very much, my Lord.
Counsel.
Thank you, my Lord, for doing justice to this matter. Thank you very much, my Lord.
Thank you, Counsel. I think that should be all for Sokoto.
That's all for Sokoto.
The court will rise and you can now exit the platform regarding this matter for Sokoto. Thank you, Abbas.